The last case that we'll review this morning is Bus versus Luhring, and it's 250760. Mr. Harding, you'll be arguing for the Scott and Julie Bus, and Mr. Lederer, you will be arguing for Lana Luhring and her law office. So whenever you get set up, we'll be ready for you. We'll let Mr. Lederer get his stuff together. Yeah. You guys got gray. I know, right?
Alternative, so.
Anytime, Mr. Harding, we're ready for you.
The court, my esteemed opposing counsel, and also the people from the court that are on the staff. I start out here by asking, when a lawyer is paid to handle a commercial real estate transaction, does their client have the right to expect that when it's over, they can actually use what they bought? The answer should be yes. Everyone in the room knows the answer should be yes. Luhring was hired to do exactly that. She drafted the lease purchase agreement and had it closed. And when it was over, Scott and Julie Bus owned a large-scale grain handling facility, a capacity of 158,000 bushels of grain. But they had no legal right to set foot on it, not to run it, not to maintain it, not to save it, because Luhring had left the access easement out. Here's what we know that good lawyers do. When a commercial property can only be reached by crossing another's land, a competent real estate attorney identifies the access issue during the due diligence, confirms a legal right of access in writing, and ensures that that right is recorded in the paperwork before closing.
So you have somewhat of a failure to inform argument that you make with regard to that. I mean, you should have told us that this lease with the purchase option doesn't cover everything. Is that kind of where you're going?
We had two things at the district court level. The primary one was that she should have gone ahead and drafted this in the way that they asked for it. They asked for it to be ironclad so that there'd be no problem in the future. But also that if that was not possible to do, and we think there's substantial evidence that it was possible to do it at that point, that even if that was not possible, that she then had an obligation to inform them about the dangers of going forward without any ability to access this property that they had purchased.
Going there, and I know the district court did not go there, but wouldn't your folks have known in 2018 that that result had not happened based on the lease with the purchase option, which then leads to your statute of limitations running?
And the statute of limitations is actually, and I may butcher the name of this case, but the Vosogi case, I think, addresses that directly, because what happened there, and it's virtually identical to the situation here, where there were failures in drafting along the way, and then in the end, when they stopped making the payments under that particular case, that was when it became apparent that there actually was a problem and that there were no damages up until the time that there was the failure to go ahead and go forward with it. Same situation here is that they started running into some family issues, and that started concerning them. But they did not know until they were locked out, until their access was blocked, that they were actually going to have damages as a result of it. So the statute actually started running in 2020. In fact, there may be an argument that it should have gone ahead and started running even after that, after the court decisions on the other case.
Can I take you a little further down the track and talk about causation specifically? Sure. So I'm looking at Julie's affidavit where she basically says, our intention was that it be included, and that was our intention all along. Does that get you where you need to go, or did she need to say it was our intention, and if that intention wasn't met, we wouldn't have contracted?
Well, Your Honor, I think that I know that had things been done differently at that point, that there would have been some other steps that would have been taken. I mean, had they gone ahead and had placed in the documentation that they would have the right to access, there would have been no problem whatsoever. If there'd been a refusal at that point, then that could have been dealt with at that point. Now, we have substantial evidence, though, that it would not have been a problem back then, because there's a joint statement of intent that was signed by everyone that they were taking over the farming operations. Then, of course, in the agreement itself, it talks about all apprehensions, and that, again, would lead people to think that that would be something where they would continue to have access. And then after that, years later, where Richard Buss went ahead and signed a permission to access the property that had him in control of the site for 30 years. Again, those are all points that point to the fact that had this been properly drafted in the beginning, that there would not have been a problem, that there would have been access, that they would have been able to go ahead and utilize what they had gone ahead and paid for and what they expected out of it.
Counsel, what about the mother? What do we have? I mean, as I understand it, there would have need to have been a signature from both the mother and the father to actually transfer a property interest. So what's the strongest evidence that the mother would have agreed to some land interest if that had been in the contract?
One thing is the joint statement of intent, which was signed by her. The facts here are that there was not a family breakdown until well after, in fact, even after they had gone ahead and paid off and actually had purchased and had title to this whole grain handling facility. The only statements that go the other way are ones that were well after the fact, where there was an ongoing issue back and forth between the parents, their son, and their daughter-in-law. Again, it's disputed facts that should be decided by a jury rather than being decided by a judge taking it out of the hands of the jury. So.
Which the Blackhawk Building Systems case.
Blackhawk is distinguishable in a number of ways. First of all, the facts are vastly different. There, in Blackhawk, what they were trying to do was, after the breakdown had occurred, they were trying to go ahead and get a non-compete enforced. Originally, there had been a non-compete among some of the drafts. That was left out. In Blackhawk, the only benefit to the non-compete was to Blackhawk itself. Here, what we have is we have a benefit going several ways, because we have a benefit to my people, taking over the farming operation, that sort of thing. That's clearly what the plan was back based upon the joint statement of intent. And so it's beneficial to the parents as well as to their son and daughter-in-law. That's absolutely, totally different than the situation with Blackhawk, where there was no evidence whatsoever that that ever would have been done had it been presented at the time that Blackhawk was entered into, when he became CEO. Here, this was supposed to be something that was going to be done between the two of them, or between the four of them, I should say. So,
Argument that the lease with purchase option meant that they would actually be buying the land?
they were getting access to it. There was talk at some point about buying the farm ground and that sort of thing, but it was not anticipated that this would in any way be tied where they had to go ahead and buy the farm in order to buy this. That was not part of what the agreement was. The agreement was just over this particular grain handling facility. And so that's why when they bought it, they went ahead, did all kinds of work to it, did borrowing, that sort of thing. Lacey.
And you'll have time on rebuttal. Mr. Lederer, whenever you're ready.
Good morning. The lawsuit may be about whether or not Lana Luhring was negligent, but the motion for summary judgment and this appeal are about proximate cause and only about proximate cause. And if you get to it, the statute of limitations.
My big picture observation there, which is where I'm struggling in this. Surface level, look at all the facts in this. There's quite a bit in dispute. There's some inferences that run in both directions. Why doesn't this go to a jury?
Sorry, why?
Why doesn't this go to a jury? Because my sense is that there is a lot in dispute and there are some inferences that run both ways on this.
Because Julie Buss, not Judy, but Julie Buss, the plaintiff, testified that she knew that the documents that Lana Luhring was preparing did not guarantee them ownership of real estate as opposed to ownership of the bins, and knew that it did not guarantee access at the conclusion of the transaction, because in the meeting between Judy and Richard on one side and Scott and Julie on the other, Judy made it clear she wasn't going to sell real estate and she wasn't going to grant an easement. You can see that in paragraph 12 of the affidavit by Judy Buss in the other lawsuit, to which there is no countervailing evidence. All of the affidavit by Judy is uncontested here, and Judy's side won that case. And it's clear that Julie understood that she was signing a document that did not give her the protection that she wanted. She knew that. Again, it's not about whether Lana Luhring did anything wrong. It's about whether or not plaintiff can prove that there is any way for the matter to have been successful for them if done differently. The problem is there's no evidence that if Lana Luhring had put in an easement or some other promise of eternal access, that Judy and Richard would have signed it. In that sense, this is exactly the Black Hawk Building Systems case. It's exactly the situation where in a business transaction, you have the opportunity to lock in the CEO of the selling entity to a non-compete, and you don't do it, and then you sue because you wind up getting competition from that gentleman. That case failed for the plaintiff against their lawyer because there was no evidence that the CEO would have signed the non-compete. It's the same situation here. There's no evidence that Judy and Richard would have signed something that saved them. And Julie's testimony, you regarded both of those statements as important in going forward since you weren't going to get to buy the land. Answer, correct. You understood in 2011 that if you didn't have those assurances, you would be risking everything, correct? At that point, we weren't worried. And you knew there was no document there that guaranteed the things that they said orally, correct? Yes, but you take family at their word, and you trust your lawyer to make sure your hiney's covered. I've always wanted to say hiney in an oral argument. But you just told me you knew that there was no language in the documents that guaranteed the things that the family said, correct? Answer, correct. There's simply no evidence in this case, and it was tested at the motion for summary judgment stage. No evidence at all that Richard and Judy would have signed a different and arguably more helpful document. It's just not there.
Focused on the same deficiency in Julie's testimony that I was asking Mr. Harding about. Why can't other circumstantial evidence fill that gap, at least for summary judgment, to get it to a jury?
Well, it can, if there is any, and there isn't. I mean, I'm quoting testimony by one of the plaintiffs. It's pretty good for my side, but you're not hearing any other circumstantial evidence here. And it wasn't heard at district court level.
The one document, I think, that is signed by everybody, that is signed by the mother, that talks about everybody's put on notice, if it's my rental land, you should be working with my son, we're transferring everything over.
Correct. 3 years after Luhring ever touched this. And the problem with that is that there is no evidence in that document that proves that in 2011 they would have signed a different document that granted an easement, because the 2014 document does not grant an easement. And when we're talking about other circumstantial evidence, then we look at 2018 when Scott and Julie buy the bins. They perform the option to purchase, and they pay all the money that's due. And now they are the lock, stock, and barrel owners of the bins. And so now the lease and the language in the lease doesn't help them anymore. Richard and Judy offered to extend the lease so that they could have access to the bins they now own. And Scott and Julie said no, because we want an easement instead. And Richard and Judy would not give it to them.
Got another question about the contract itself. So do you think, could there be some sort of provisions in a contract that are so accepted, so standard, that like the nature of the contract could be reasonably to infer? And so I'm asking, and I'm not sure whether this contract is on that line, but it does seem kind of odd that you would buy just the grain bins, all the stuff under the grain bins, the electrical, all of that, but not any possibility of actually keeping those huge structures on the land where they are, or any access to get to them. So like, is there anything about the nature of the contract itself that is reasonable to infer that, well, of course they would have allowed some sort of other interest, because who would enter into this type of contract if it didn't?
From 2011 forward, that's what happened, because it's a family thing. And the best thing I can say for you on this is a family farm situation. There are, if you read all the materials that are available to you, it's clear that there's problems between Judy and Julie. And there we go. And people do things, and their lawyers do their best to help them in hopes that the family relationships can make the difference. And frequently they do, but sometimes they don't. Sorry.
Protecting your Heine theme, when Julie testified that, hey, we had this conversation after the parents left, and say, hey, there are going to be some problems here. We need this ironclad. Shouldn't a jury understand that? That maybe there should have been some other representation here that would have occurred to protect them, their hiney?
Again, the appeal and the motion for summary judgment are not about whether or not Lana Luhring was free of negligence. The question here is proximate cause. They have to prove Lana Luhring was negligent, but they also have to prove that that negligence was the proximate cause of their situation that occurs in 2020. And they can't prove that that Richard and Judy would have signed a different thing had she drafted it.
And so in that manner, I was told a while back that there's no such thing as proximate cause anymore. I know. And so I'm like, does that pertain to this legal malpractice? Or are we to look at scope of liability instead of proximate cause and not like weigh this Blackhawk case in the same way?
All I can say is that the Blackhawk Building Systems is the seminal case in legal malpractice law in the state of Iowa. It has not been touched since 1988. It's good law. It requires proof for anyone who's going to sue a lawyer for legal malpractice in the state of Iowa to be aware of it and to require proof of proximate cause. I see my time is up. Thank you.
Thank you very much. On rebuttal, Mr. Harding.
There's also no proof that she would not have gone ahead and signed it back in 2011. In fact, she went ahead and signed that she was agreeing to go ahead and go forward with moving the family farming operation over to her son and daughter-in-law.
Fatal to your argument if the inference could go either way. Maybe she would have, maybe she wouldn't have. Wasn't the summary judgment correctly granted?
No, because when it's an issue, there's disputed facts, it should go to the jury. Ruling that, as here, where what the trial court did was they granted summary judgment by resolving disputed facts against the buses.
Specifically gets you to where you need to go on causation, and I accept that we may not know which words apply, but causation generally speaking.
Well, remember, we have two different bases that we're going forward on. One is that there should have been access language that was included. And we do have that, at that point at least, the relationship was going well. And in fact, a lawyer drafting something of this sort should have gone ahead and known that sometimes family relations come apart. We see that fairly frequently, husbands and wives, parents, children, that in order to go ahead and avoid that sort of thing, it should have been in the original documentation, and it wasn't. And if there was a reason that it couldn't go into the original documentation, then they should have had explained to them the problems that they would go ahead and run into here.
On that second theory, and this kind of goes to Judge Buller's question way back at the beginning of the argument, the theory that if she would have informed them that this isn't there and it's not going to be signed, then wouldn't your burden be to prove that your clients would have not gone forward with signing it in that situation? And what proof do we have that, given their strong interest in taking on the farm and their hope that everything would work out? What would be your strongest case that they would have halted and not signed it if they had been informed that there was a risk here?
One thing, they would not have gone out, borrowed substantial amounts of money, upgraded this facility, put all kinds of money and all types of effort, all types of work into going ahead and making it into a more valuable facility, a more functional type of a facility, had they known that they could go ahead and have the rug pulled out from under them at any point. The point was raised, too, that there was an offer to, okay.
And I understand the logic of what you just said. Did anybody testify they wouldn't do those things but for the contract issue?
No, no testimony on that I can remember.
Another factual question related to that, if I'm recalling correctly, I think around that time before they started spending all that money, there was some evidence that their lenders or the farm's federal folks like required them to go and get that second document from the dad only agreeing that they could continue to use this for the life of the life of the grain bins or something. So wouldn't that kind of cut against the idea that I mean, at that point, they had some knowledge there was a risk, presumably, if they were having to get that second document.
I think that it actually cuts to the fact that they were cooperative at that point in going ahead, and in fact, I'm looking at it here that it's 30 years into the future, and that was in 2014, long before these problems, the additional problems arose. Basically, what we're saying here is there are substantial disputed facts that should be left to the jury to go ahead and decide. Here, a ruling that would affirm the summary judgment doesn't just decide this case. It says that a court may weigh disputed facts and choose one side's version and still call it summary judgment. That's not the law. It's never been the law. It shouldn't be the law. And this court should say so clearly on that. At the beginning, I asked one question, whether a client should expect when it's over that they can actually use what they bought. She didn't do it. Scott and Julie Buss paid the price for what Lanning was paid to prevent, what Luhring was paid to prevent. We ask the court to reverse. Thank you.
Thank you, counsel, for the excellent arguments in the briefing, and my colleagues and I will get a decision out as soon as we can. And with that, Buss versus Luhring is submitted. Thank you.